I appreciate
Yeah.
very much being part of this conference. And thank you, Giancarlo, for inviting me. Great honor for me. And now let's look if it works with the slides. Can you see something? I'll talk about the German Equal Treatment Act. Can you see my slide?
No, I can't.
Oh, that's a problem. Sorry. So let us see
No
what
problem.
we can
No
do.
problem.
Yes, what we can do. I'll go to Zoom first again. And now whatever to do. Oh, freigeben maybe. Mm-hmm.
Where
Equal
do you have share? Share. Great. Now, perfect. Now
right.
it's perfect.
Okay.
Thank you. Great.
So, well, I'll talk about the German Equal Treatment Act, how Germany likes, how the German legislation aims to restrict discrimination. In general, it is widely agreed that discrimination prevents or destroys social cohesion and stands in the way of peaceful coexistence. Discrimination, yeah, of all kinds, and the demand for its suppression are topics of global debate with different social interpretations of what constitutes discrimination. In Germany, one can follow this in the daily press. Recently, the Pope was criticized for his statements as head of the Catholic Church regarding, this was his word, gender ideology and the role of women, emphasizing that a woman's role involves fruitful receptivity, care, and lively dedication. Critics emphasize that all people should be able to develop freely, regardless of their gender or sexual orientation. Elsewhere, discrimination poses a threat to life and safety. In China, for example, I just returned from Shanghai, as you know, Carlos, there's a strong presence of disability organizations and their efforts. However, for certain ethnic and religious groups, the Chinese government employs cultural assimilation through re-education measures. And this is justified by local authorities as an anti-terrorism campaign. Yet from a Western perspective, it is viewed as discrimination and, better said, a crime against humanity. This illustrates the significant disagreement over what should be considered as discrimination and what should not. In Europe, we have laws against various forms of discrimination. Let's have a look at the historical background. As Professor Freddy Nishihara pointed out yesterday on yesterday's conference already, 3/4 of a century ago, the UN Human Rights Commission adopted the Universal Declaration of Human Rights, recognizing the fundamental rights of freedom of all people. However, human rights continue to be violated through various forms of discrimination. The United Nations Declaration of Human Rights was, of course, only a beginning. To further combat discrimination, the Council of the European Union issued directives which each member state of the Union was required to incorporate into national law. These directives address the prevention of racism and various forms of unequal treatment. And in line with these guidelines, the German legislature enacted the General Equal Treatment Act in August 26. According to Section 1, the purpose of the law is to prevent or eliminate disadvantages based on race or ethnic origin, gender, religion, or worldview, disability, age, or sexual identities. The law empowers the powerless, states the foreword of the publication. In this context, it is important to note that under the German Basic Law, all people are equal before the law. However, this applies to the relationship between individual citizens and the state. All state authorities, such as the police and law courts, are bound by the constitutional prohibition of discrimination and the general principle of equality. The German Equal Treatment Act, however, now applies to interactions between private citizens. It is not applicable in the public law sphere, but it extends the principle of equal treatment to certain areas of civil law. The addressees of the law are the citizens themselves. This limits private autonomy and has far-reaching implications for companies, particularly in labor law. The content of the law. This means The law provides protection against discrimination in professional life, especially in employment relationships and in everyday civil transactions. So let's look at the first part of the regulations. Prohibition of discrimination in the workplace applies to all areas related to working life, including job applications, employment contracts, training, membership in a labor organization, and termination of employment. Anyone experiencing discrimination for the reasons outlined in Section 1 of the law has the right to complain, a right to refuse service, and if the employer is responsible for the breach of the non-discrimination clause, a legal claim for compensation of damages. The list of grounds for discrimination is exhaustive, meaning other forms of discrimination are not covered. For example, a smoker cannot invoke the law's protection due to discrimination in the workplace based on smoking. Additionally, different treatment based on essential professional or religious requirements may be permissible. Finally, under specific exceptions by legitimate aims, different treatment based on age, such as setting minimum or maximum ages, may also be allowed. The next part of the law is the prohibition of discrimination in everyday transactions. The law also offers protection in so-called mass transactions. This refers to transactions that typically occur under similar conditions for a large number of people, regardless of individual characteristics. Examples include shopping in supermarkets, booking hotel rooms, renting private rooms, etc. For these types of transactions, the reasons for discrimination listed in Section 1 of the law must not lead to disadvantage. In cases of civil discrimination in such transactions, affected individuals have the right to claim compensation as well as to demand correction and cessation. However, there's a list of exceptions. Differential treatment may be permitted if specific objective grounds are present, as outlined in Section 20 of the law. For example, such treatment may be justified to prevent hazards or avoid harm, protecting privacy or safety, and so on. To illustrate all this, let us look at a few court decisions. I picked up 3 cases related to the prohibition of age discrimination, along with 2 decisions concerning additional grounds for discrimination in the context of housing rentals. The grounds for discrimination prohibited by the law are generally strictly enforced. The case law, however, is diverse and expensive. As we have already seen, the law, with its complex principles and exceptions, is designed to be as complicated as possible. The law has often been criticized for being poorly crafted, despite its good intentions. In practice, it can feel like navigating in the dark. For instance, in each case, it must be assessed whether certain criteria are essential for the job, such as when a perfume store seeks a young employee, or a company wants someone with perfect German language skills. As a result, it has become unclear exactly what rules apply. So let's first look at court decisions on the ground of age discrimination. The lawsuit concerned a job advertisement. According to the Heilbronn Labor Court, an employer is prohibited from even hinting at the age of a desired employee, unless age constitutes an essential and decisive professional requirement. The court found that the phrase, "as a digital native, you feel at home in the world of social media," indicated direct discrimination based on age. A digital native is understood as someone who has grown up with digital technologies and is adept in their use, typically associated with a particular generation. This suggests that the company is seeking not only someone with specific communication skills, but someone who inherently possesses this attribute due to their age, disadvantaging other applicants. Consequently, the court held that the company must compensate the rejected applicant with 1.5 times the achievable monthly salary. Another case of age discrimination involved the inclusion of a referee based on age. The court decided in favor of 47-year-old referee Manuel Gräfe, who was awarded 48,500 euros in damages after being excluded by the German Football Association based on his age. In that season, the German Football Association decided not to include Gräfe in its referee roster, citing a standard practice of seizing appointments of elite referees at age 47. Gräfe challenged this decision and won in the Frankfurt District Court. The court found that the age limit of 47 was arbitrary and entitled Gräfe to compensation. It ruled that declining performance or increased injury risk with age did not justify a strict cap, especially as there was no scientific or empirical evidence indicating that age 47 is critical for a referee's capabilities. No entry for seniors, is this okay? On the other hand, a 44-year-old plaintiff was denied compensation after being refused entry to an open-air event in Munich in August 2017. The event featured electronic music from 30 DJs, was limited to a maximum of 1,500 attendees, and did not have advanced ticket sales. Tickets could be purchased only after passing the entrance check. The German Federal Court of Justice ruled that age-based discrimination did not apply when the composition of an event's attendees is specified from the outset, and entry to such a gathering does not fall under the civil anti-discrimination provisions, as it does not constitute a mass transaction where entry is granted without regarding to individual characteristics. So let's look at court decisions in the area of rental law. At first, a case of unlawful discrimination. The Essen District Court awarded compensation of 1,500 euros to a rejected apartment applicant due to discrimination based on ethnic origin. The plaintiff did not need to prove that he was explicitly excluded from the applicant pool due to his ethnicity. Instead, he only had to present sufficient evidence suggesting discrimination. This was demonstrated by the fact that he received no response to his initial application and was only considered after reapplying under a German-sounding name. It is further especially unlawful when a rental listing specifically wants only Germans, as that statement implies not only nationality, but also ethnic origin in general usage. The Augsburg local court therefore ordered the landlord to refrain from such restrictions in his listings and awarded compensation of 1,000 euros to the apartment seeker from Burkina Faso, Africa. These situations can naturally lead to significant conflicts. What landlord would like to fully reveal their selection criteria for tenants? So let's look at circumstances that do not constitute discrimination. The restriction on personal autonomy imposed by the law is especially felt in areas involving a strong personal element. Legislators have recognized this to some extent and declared that the law's provisions do not apply to contractual relationships where a particular closeness exists between the parties. In rental situations, this can specifically apply when the parties or their relatives share living space on the same property. Finally, let's look at the evaluation by the latest status report. In September 24, the Federal Anti-Discrimination Agency established for this purpose presented its fifth status report. The recently published report highlights a steady increase in inquiries related to discrimination, indicating that people are increasingly asserting their right to equal treatment. Public discourse has evolved that discrimination becomes a topic of widespread discussion. According to the Anti-Discrimination Agency, the law's protections remain insufficient. Discrimination based on social status, for instance, is not covered. The report concludes with a recommendation to implement reforms. The law should be extended to cover federal government actions with nationality to be included as a specific category of discrimination, independent of ethnic origin. The restriction of the application to mass transactions should be removed. The level of protection must apply equally to all contracts. The report also recommends removing exemptions for religious communities and rental agreements with close personal relationships, and further demands. Okay, it is unlikely that the Anti-Discrimination Agency, which is extensive personal resources, would fail to identify weaknesses in anti-discrimination protections. And it is quite possible that there are still gaps in protection against discrimination. However, some of the improvements currently being demanded seem to exceed the original objectives. Proposed expansions, such as including social status as a prohibited discrimination criterion, touch a general idea of justice. This leads us back to the fundamental question of what constitutes discrimination, and further, to whether the desire for justice in every specific case can be effectively encapsulated in law. How define discrimination on the ground of social status? We all desire social peace, and along with it, as much freedom as possible. The basic needs of all people are the same. Justice, peace, and freedom exist in a field of tension and should be established in a balance. One person's freedom competes with another's freedom. But last not least, there is one recommendation from the Anti-Discrimination Agency that strikes me as important: the expansion of alternative dispute resolution methods. The report notes that mediation procedures offer significant advantages over court proceedings, as they are less burdensome and more cost-effective. However, it emphasizes the need to ensure that a conciliation process becomes mandatory if requested by a person who has experienced discrimination. Thank you so much for your attention.
Great, great, great. Thank you so much. I congratulate you, Angelica. It was a perfect presentation.
I like to do it.
And your information about this way to prevent discrimination, it's perfect. I love it. I believe the last phrase say that the mediation needs balance. That's true.
Yes,
that's true. That's
exactly.
This peace depends on balance.
Yeah.
Yes. We need to have this kind of balance to live in harmony. That's very important. That's my opinion. Both parts need this change.
Yeah.
Thank you very much. Thank you. It was bright. Perfect. Thank you so much. And later on, about in Brazil, about 1 p.m. Freddy. Fred's coming right now. 1 p.m. we'll have our other presentation. Dear Fred.
Yes. Hello, Freddy.
Freddy Ortiz Nishihara is coming.
Yes,
in Brazil, Angelica.
Hey. Good morning to all of you.
Good morning, my friend. How are you?
Yes. Very well, very well. I was sick, a little sick yesterday, but I'm now getting well.
Look, you've missed it out. The
yes,
perfect presentation of Angelica. It was perfect.
Yes, I came here by that because I want to be present in her presentation.
She brought us some good new information and very balanced also information.
Yes.
And she said a sentence, a phrase that for me was very important. Peace depends on balance. Perfect.
I know that she has the most actual information. Very good, very nice, Angelica. We are here to hear. We are waiting for to hear you, but it's very special date for to meet you and to have a very good interchange of ideas with you.
I heard your presentation yesterday. I heard your presentation yesterday, and it reminded me on mine in the purpose of the Human Rights Declaration, because you mentioned it too. You mentioned it.
Yeah.
Yeah, and it's very important. I know your skills. It's always what you are busy with.
Thank you.
Very good.
Thank you.
So, my dear Freddie, thank you,
Yes.
Christina. My dear friend,
Okay.
Christina. It's over for now, but later
Yes.
on, about 1:30 p.m. Brazilian time,
Mhm.
Yes.
we have my
Yeah,
dear friend Christina.
Yeah.
Christina is
Christina.
going to.
Yeah,
Christina is going
So
to
we'll
talk.
see us again.
Okay.
Yes.
Oh,
It's
first,
okay.
thank you. Thank you
Bye.
very much. For me, it's
Bye.
an honor and a pleasure having you here, Angelica. And
Thank you
my
for
dear friend,
inviting me.
Patty. Christina, see you later. Bye.